Exclusionary lists have been around for a long time. Banks have relied on them as one means of identifying potentially fraudulent parties to a transaction. The lists have become an important part of the mortgage process because they are typically generated by investors and GSEs, sometimes warehouse banks, and essentially a lender cannot conduct business with those strategic partners if any of these excluded parties are connected in some way to their loan file. And so the lenders are kind of compelled to rely on these in some way as a method of risk management. But as a method of risk management, it's a really ineffective and inefficient way of doing it for several reasons. First of all, there's no indication whatsoever why someone is on an exclusionary list. There's no backup provided, and they're provided in a kind of a strange way. The investors and warehouse banks sort of say, here's the list. We won't buy a loan or fund a loan that has anyone attached that's on this list attached to it. However, we're not going to really tell you why, and you can't share this information with anybody. So it's kind of like a double secret probation list that lenders are compelled to rely on. And some may feel a sense of security that they have this, but the lists themselves are highly inefficient. And they're inefficient, again, because you don't know why people are on there. I've known instances where people have found themselves on the list, had no idea why, and couldn't get themselves off the list. Because even the investor, these lists get accumulated year after year, and they're not something that's looked at freshly. It's just like you just keep adding people for some reason. They could be on there because there's a criminal charge against them, or it could be as simple as something like they didn't like the way they did business. They didn't communicate properly, or they were, offensive some way to someone. And so it could run the gamut, and it differs so completely from what we do, which is doing an objective analysis of risk, looking at the background, looking at the license insurance, looking at all the factors, and when you put them together, allow us to really give an objective risk rating, and everything's behind it. So when we rate somebody and we tell a lender this person is a caution or high risk, they don't have to guess why they're on there. We tell them why they're on there. We give that information freely, and it makes it, I think, much more fair to all the parties involved. It makes it much more reliable, and it takes the lender out of the realm of potential legal liability. Because look, when we make a decision at Secure Insight to rate someone caution or high, we do it with tremendous amount of contemplation. There's an automatic appeal process where we interact with the subject of the investigation, and we make sure we get it right, because we know if someone's a caution or high, they very likely are not going to be able to do business with a lender, and that's a serious consequence. With the exclusionary list, people can be essentially blackballed in the industry, not be able to conduct business. They don't know why they're on there, no backups provided, and lenders have potential liability. If they say to someone, we can't do business with you because you're on this list, and I'm the lawyer and I'm now going to lose this client, and you can't even tell me why I'm on there, they run the real risk of business defamation and so on. And, it's a significant issue. So we come at it differently. We give the lender the comfort in knowing that if they're going to have to make an adverse decision, that they're making it based upon real objective evidence.